This is big. God, how cool is it?
EF and the government is going to fight this every step of the way. And sooner or later, it will land before the Supreme Court.
The Supreme Court will be taking up a gun rights case.
One proposal allowing them to carry firearms without a license.
Breaking news from the State House, one of the big bills in front of the Senate.
The first major federal gun safety legislation in decades is now moving forward.
Members of the Senate are focusing on gun rights in the wake of the Supreme Court's Bruen decision.
The Supreme Court just received an emergency petition that could completely eliminate every firearm permit requirement in America within months. Not years, not decades. We're talking about a constitutional earthquake that would end all government permission slips for gun ownership across all 50 states. From purchase permits to carry licenses, the entire system could collapse overnight. This isn't speculation or wishful thinking. A federal judge already struck down an entire state's permit system, calling it unconstitutional from top to bottom. The ruling sent shockwaves through the legal community because just 2 years ago, experts said this was impossible. Now it's spreading like wildfire through the federal court system. The judge didn't just tweak some requirements or suggest minor reforms. He issued an immediate injunction halting the entire permit system. His reasoning was devastating for gun control advocates. After examining historical records from 1791 to 1900, he couldn't find a single state that required permits to own or carry firearms. Not one. Even more damaging to permit systems, the judge discovered something buried in early 1900s legislative records. When permits first appeared, lawmakers explicitly stated they were designed to keep guns away from freed slaves and immigrant populations. The racist origins of permit systems became part of the official court record. When the state appealed this bombshell ruling, a 3-judge panel upheld it by a 2-1 vote. Then something extraordinary happened that legal experts are still analyzing. The full circuit court was asked to review the case, and they refused. By declining to hear it, they let the panel's anti-permit decision stand. The constitutional test being applied here changes everything about how gun laws work. It's called the text, history, and tradition test from the Bruen decision. Under this standard, if a gun restriction didn't exist when the Second Amendment was ratified in 1791, the government must prove a historical analog from that era. No analog means the restriction is unconstitutional. The court's historical analysis found zero precedent for permit systems.
Now, this is the most significant Second Amendment ruling in more than a decade.
Will allow scrutiny for all gun laws pertaining to everything: assault weapons, age restrictions, restrictions on magazines.
This ruling strikes down a New York law that put restrictions on who could get a license to carry a gun outside of the home.
They really don't know what to do with this one, which is always a good thing to see.
Topics ranging from gun rights and private property laws to foreign property confiscation.
This is not a gun decision.
No.
It's not. This was not decided on Second Amendment grounds.
Several founding-era state constitutions explicitly protected carrying arms without mentioning permits or government approval. Pennsylvania's 1776 Constitution declared people have the right to bear arms for defense of themselves, period. No qualifications, no permits, no government permission needed. Vermont's 1777 Constitution contains similar language, and Vermont has maintained that standard for 247 years without ever requiring permits. The judge noted this real-world example proves society can function safely without permit systems. Anti-gun advocates often cite the Statute of Northampton from 1328 as historical proof of carry restrictions. The judge demolished this argument. That ancient statute prohibited going armed to terrify the king's subjects, meaning it banned threatening behavior, not simply carrying weapons. Using a 700-year-old English law to restrict American constitutional rights didn't hold up under scrutiny. The Department of Justice's position in this case shocked everyone, including gun rights advocates. The current administration's DOJ didn't argue for reforming permits or making them shall issue. They went nuclear, arguing that any permit requirement whatsoever violates the Constitution. Their comparison was impossible to ignore. In 1966, the Supreme Court struck down poll taxes for voting in Harper v. Virginia Board of Elections. The principle was clear. You cannot charge citizens money to exercise constitutional rights. The DOJ argued permit fees are poll taxes on the Second Amendment. The numbers back up their argument. Permit fees range from $50 in some states to over $300 in others. Mandatory training courses add $100 to $500 more. In states like Illinois, the total cost reaches $556 when including fees, training, and fingerprinting. For low-income Americans, these costs effectively price them out of their constitutional rights. Processing times create another constitutional problem. New Jersey averages 137 days to process permits. Some New York counties take 180 days. The DOJ argued that making citizens wait months to exercise a constitutional right is like making them wait months to speak freely or practice their religion.
This case could reshape how far states can restrict your right to carry.
But public safety concerns must be addressed in ways that are lawful. This rule is not.
Not giving notice, well, that's required. Well, and when you take that away from people, you don't follow the rulemaking process, and you have to invalidate the rule.
There is a difference between states deciding how they want to regulate any number of things versus stripping people of their rights to self-defense.
Give us transparency in how you're going to handle them, and if there's a roadmap of what you're going to follow that's more clear, then it's going to be a fair process for everyone.
This is an issue that every gun owner should be concerned about, and we in Congress should be concerned about it too.
This is a case that's been bounced around back and forth throughout the court system.
Denial rates expose the arbitrary nature of permit systems. Los Angeles County approved only 0.4% of carry permit applications before recent court rulings forced changes. Hawaii issued an average of 12 carry permits annually for the entire state. The DOJ called this de facto prohibition through bureaucratic obstruction. 25 states with constitutional carry joined forces to file briefs packed with real-world data. These states eliminated permit requirements between 2010 and 2024, creating a massive natural experiment. The results contradicted every prediction from gun control advocates. Arizona eliminated permits in 2010 amid warnings of skyrocketing violence. Instead, Arizona's violent crime rate dropped 6% over 5 years, while the national average fell only 3%. When Kansas adopted constitutional carry in 2015, critics predicted Wild West chaos. Kansas saw its murder rate decrease 11% over 4 years. Texas became the ultimate test case in 2021 with its 30 million residents going permit-free. Violent crime dropped 4% in the first year and another 3% in the second year. Across all 25 constitutional carry states, not one experienced significant increases in gun violence compared to national averages after eliminating permits. The coalition's data revealed how permit costs create discriminatory impacts. In wealthy zip codes, permit approval rates run 60% higher than in low-income areas. The difference isn't criminal history, it's affordability. Poor Americans are being priced out of self-defense. The constitutional crisis forcing the Supreme Court's hand involves completely different standards in different parts of the country. The Fifth Circuit declared all permits unconstitutional. The Second Circuit upheld New York's permit-to-purchase law. The Ninth Circuit upheld California's entire system, including discretionary carry permits. This creates absurd situations. Someone in Louisiana has a constitutional right to carry without permits. That same person moves to New York with the same clean record and becomes a felon for exercising the same right. Legal scholars call this a constitutional checkerboard that makes a mockery of equal protection. The split's real-world impact is staggering. Fifth Circuit states saw permit applications drop 89% after their ruling because people realized they didn't need government permission. Meanwhile, New York processed 438,000 applications last year, denying 34,000 often for subjective reasons like insufficient need. California's system under the Ninth Circuit gives county sheriffs complete discretion. Los Angeles and San Francisco issue almost no permits, while rural counties issue them freely. Federal judges have written opinions practically begging the Supreme Court to resolve this chaos. Anti-gun states aren't waiting for the Supreme Court ruling. They're already drafting workaround legislation to maintain restrictions under different names. California's template would eliminate permits but require firearm safety compliance certification with identical requirements, fees, and delays.
We here at the USCCA want to see Congress pass laws that will help reduce crime without infringing on the rights of law-abiding citizens.
Everybody has a right if they're a responsible adult.
Saying setting a higher threshold in an emergency could mean life or death.
When things sound really good for gun owners in court, that doesn't mean it's over.
The government may not regulate individuals' possessions of weapons for self-defense.
Constitutional protections of your home are absolute.
It triggers something in me that something has to be done.
New Jersey's draft eliminates carry permits, but requires ammunition purchase approvals for every transaction with 30-day processing periods. You could own guns without permits, but need government approval each time you buy bullets. New York is considering mandatory firearm liability insurance requiring $1 million coverage. Insurance companies estimate annual premiums of $800, $1,200, more expensive than current permit fees. The goal is maintaining financial barriers under a different legal structure. Illinois drafted a public safety training verification system required before any firearm purchase. Only state-approved instructors could provide training, and the bill lets state police limit instructor numbers, creating artificial scarcity. Hawaii's proposal is the most extreme, requiring firearm storage at licensed facilities rather than homes. Gun owners could visit their firearms during facility hours but couldn't keep them for actual self-defense. Constitutional scholars believe the Supreme Court will anticipate these schemes. Their opinion could broadly prohibit any system requiring advance government approval, fee payments, or arbitrary delays before exercising Second Amendment rights, regardless of labels. The implications extend beyond guns. If the court rules that constitutional rights can't require government permission slips, it could affect protest permits, parade licenses, and other First Amendment restrictions. The principle that rights aren't subject to prior restraint could reshape constitutional law. State governments are scrambling to prepare. Some are already discussing constitutional amendments to explicitly allow permit systems. Others are exploring interstate compacts to maintain permit requirements regardless of Supreme Court rulings. The timeline is critical. The court could decide whether to hear this case within weeks. If they take it, oral arguments would likely occur this term with a decision by June. That means every permit system in America could be gone by summer. Gun rights groups are mobilizing supporters to prepare for rapid changes. Training instructors are expanding capacity, anticipating millions of new gun owners if permits disappear. Ammunition manufacturers are increasing production, expecting demand surges. The political implications are enormous. This case could energize voters on both sides heading into election season. Politicians are already staking out positions, with some promising to codify permit requirements if the court strikes them down. Law enforcement organizations are split. Some police chiefs support permits as public safety tools. Others argue criminals don't get permits anyway, so the system only burdens law-abiding citizens. The court will likely consider these perspectives. The historical record keeps growing as researchers uncover more evidence. Recently discovered documents show that several founders explicitly rejected licensing systems for arms, comparing them to British tyranny. These findings strengthen the case against permits. International observers are watching closely. America's gun laws influence global debates on self-defense rights. A Supreme Court decision eliminating permits would send shockwaves through countries considering liberalizing their own gun laws. The economic impact could be substantial. The permit industry employs thousands in training, processing, and administration. These jobs could disappear overnight. Conversely, eliminating permits could boost firearm sales and create new economic activity. Whatever happens, American gun ownership is about to change dramatically. Either permits survive in some form, or 50 states suddenly become constitutional carry. There's no middle ground in this case. That's it for today, folks. See you in the next video.